In this video, we're going to be discussing the liability risk. This is primarily from Chapter 19 of the Rada-McNamara text. We're going to start with a look at the basis of a legal liability, then we'll talk a little more about unintentional and intentional torts, then we'll look at the elements of a negligent act for a legal liability to exist, then we'll turn to an application of legal liability, then we'll look at some other concepts such as imputed negligence, defenses against negligence, exception to the burden of proof being on the victim, and we'll look at examples of the special case of tort, which is absolute or strict liability. So let's get started. The basis of a liability is a legal wrong, and a legal wrong could result from one of three things. First, a breach of contract, a tort, or absolute or strict liability, which is really just a special case of tort. A breach of contract, a contract being where two parties agree to perform certain things under the contract, is typically not insurable, particularly when the breach is voluntary. That type of risk can be transferred through a surety bond, and we'll talk about surety bonding later in the course. Next, a tort. The term tort is a catch-all. It's a catch-all label for any wrong that is not a breach of contract. There are intentional and unintentional torts. We'll talk about both of those in just a moment. But first, what characteristic of an ideally insurable risk would an intentional tort violate? Well, remember that risks must be fortuitous in order to be insurable. An intentional tort is not fortuitous. It is not beyond the insured's control, since they engage in the tort voluntarily. Absolute or strict liability is another legal wrong. This is a special case of tort because fault or negligence is not a factor in establishing legal liability. We'll look at some examples of this later in this lecture. But note first that we are in the area of civil law, not criminal law, when establishing a legal liability. However, you'll see that some things can be both criminal and civil and therefore result in a legal liability and can even be insurable. Let's look at unintentional and intentional torts. First, unintentional torts. An unintentional tort is a legal wrong that was accidental. These result from negligence, and because of that, they're generally fortuitous. Maybe an employee leaves a small puddle after cleaning an area that's a high traffic area, and someone slips and falls. This would be considered an unintentional tort. Another unintentional tort is simply accidentally running a stop sign and running into someone that's coming through the other direction. Since these are unintentional torts and result from negligence, they're fortuitous and they are insurable. These are the source of most insurable liability risks. Examples of intentional torts are assault, false imprisonment, fraud, trespass, defamation. Defamation is when somebody says something publicly that is negative against another person and injures that person, such as the case of Shirley Sherrod. Shirley Sherrod made some comments that were considered racist by some and lost her job as the director of the USDA over those events. These are generally not insurable. Why not? Because, as I just said, they're not fortuitous. But there are significant exceptions. These are when the act was intentional, but the outcome was not and could not have been foreseen. So, for example, if you intentionally run a red light, but you didn't know that another car was coming through, you certainly didn't intend for the result. And in fact, sometimes a person even breaks a criminal law, such as drunk driving. Even though a person might even be convicted of manslaughter, the civil liability, the civil damages from that loss are actually unintentional and therefore insurable. Now let's look at the elements of a negligent act for legal liability to exist. Often these are just termed the elements of a legal liability. These are often just termed the elements of a negligent act. They are legal duty, breach of duty, actual damages, and proximate cause. But these first two constitute negligence. which is why I say these are the elements of a negligent act that must exist for a legal liability to exist. Let's look at them more closely. Again, you have a legal duty and a breach of duty, and together, these equal negligence. The legal duty actually depends on the credentials, education, and experience of the tortfeasor, the person committing the tort. In other words, a person who is an expert, has a degree, or some other type of credential and years of experience in an area owes a higher level of duty to others than someone who has no credentials, education, or experience. If I were to be giving insurance advice to someone because of my credentials and my education, I would owe a higher level of duty than someone who's never studied or worked in insurance. And similarly, when you receive your college degree in whatever area you're studying, you now owe a higher level of duty in that area to others when giving advice. And if damage results from your advice, you could be held to a higher standard of duty than you were before you received that degree. A breach of duty is, of course, when you fail to meet the level of duty that you owe to others. But even with duty and breach of duty, there is no cause for action unless there are actual damages. For example, if you open a gallon of ice cream and you find something in there that shouldn't be, as once happened to me where I found a fly in a gallon of ice cream, I never ate the ice cream, I didn't get sick, nothing bad happened. The only thing that I could get back was the cost of the ice cream. So even though I might have felt that I should be able to sue the company for damages, there were really no actual damages because I wasn't actually injured. So there are several types of actual damages. Compensatory, which indemnify the insured. These include special damages, which are out-of-pocket cost of the victim, medical bills, and the cost to repair and replace property, as well as lost wages, any kind of rehabilitation, any cost that the victim incurs that they would not have otherwise incurred if the accident hadn't happened. Then there's also general damages, such as pain and suffering, loss of consortium, inability to perform certain tasks. While these do occur because of the accident, they're not easily quantified or given a financial figure. Society, and sometimes specifically juries and judges, will put a number, a price on these damages so that the victim of the accident can be indemnified. Then there's also punitive damages, which are not compensatory. Punitive damages are punishment. Usually these exist when gross negligence is involved, and often this involves a court case where a judge or jury awards those punitive damages. So while the victim actually receives an amount for the punitive damages, they don't actually indemnify the victim. In some cases, punitive damages can be multiples of the compensatory damages. In some states, however, punitive damages are significantly limited or eliminated. Last, proximate cause. This just means that in order for there to be a legal liability, there must be an unbroken chain of events that starts with a breach of duty that ultimately leads to the actual damages. So for example, if someone yells fire in a crowded theater and many people run out of the theater, unfortunately trampling over one person and killing them, the person who yelled fire would actually be legally liable for that death because it was their initial action that led to the actual damages, particularly if you can show that that person could have foreseen that loss, even knowing that there was no fire. Now let's look at an application of legal liability, and that is property ownership. When you own property, you have a significant duty to keep your premises safe, but the duty you owe when you own property depends on the status of the visitor. So there are three different types of visitors. First, the trespasser. Second, the licensee. And third, the invitee. A trespasser is someone who clearly has not been invited on your premises. To those people, you owe no positive duty, but you're not allowed to set up traps. A licensee is someone who comes onto your property, but not necessarily for your benefit. Typically, social guests are considered licensees, but sometimes they're escalated to the level of invitee. To them, you're required to warn of non-obvious safety hazards. So for example, if you have a porch that leads up to your front door, if one of the steps on the porch is broken, you owe them a duty to warn them to either avoid that step or to walk very carefully over the step. To the invitee, you owe the highest level of duty. The duty to the invitee is to keep the premises safe. An invitee is someone who comes onto your property for your mutual benefit, such as a customer or a service person. Now let's look at some other related concepts. Imputed negligence. This means that in some circumstances, one person can be held responsible or liable for the negligence of another. That's imputed negligence. It's also commonly referred to as vicarious liability. For example, an employer of an employee's actions. The situation I mentioned earlier, where someone cleaning up might leave a puddle, and if you fail to put signs and to keep people out of that area, and someone slips and falls and injures themselves, the employer might be responsible for that employee's actions. The owner of a vehicle is responsible for the damage by another driver if they give that person permission to drive their car. Another example is dram shop laws, where bar owners are legally liable for injuries caused by a customer who drank too much in their bar and goes out and, for example, causes a car accident. The imputed negligence would be that the bar could be sued for the resulting injuries and damages. There are a couple of other relevant legal concepts to legal liability. First, defenses against negligence. A defendant has certain defenses against being found negligent and therefore liable or totally liable for damages. First, contributory negligence. Contributory negligence is no longer common in the United States, but historically, more than 150 years ago, in some cases, if there was someone else who contributed to an accident, such as a fellow employee or you yourself, but the employer had also created a somewhat unsafe work environment, the employee was barred from recovery from the employer because others contributed to the accident. We'll look at that more when we talk about workers' compensation. But again, this really no longer exists. What's more common in most states today is comparative negligence. Under comparative negligence laws, if more than one party is partially responsible for an accident, then both are partially financially responsible for the damages that result from that accident. So in some cases, for example, if there's a car accident, and let's say that one driver was found 80% responsible and the other driver was 20% responsible or negligent, it might be the case that the first driver has to pay for 80% of the resulting damages and the second driver pays for 20%. Finally, there's assumption of risk. There are certain activities that you can do that involve a certain level of assumption of risk. Say, for example, you park your car right outside of a ballpark, and a fly ball hits your window and breaks it. Because you assume the risk of parking your car right next to the ballpark, you would not be able to sue the ballpark owners. However, if you're driving by the ballpark and the ball happens to hit your vehicle and do damage to the car, that would not be an assumption of risk, and you could therefore sue the ballpark owners. Finally, last clear chance. If you have the last clear chance of avoiding an accident, even though you were the victim of the accident, you might not be able to sue or to claim any damages from the defendant. Say, for example, someone is parked in an illegal parking spot. Even though that person was somewhat liable, if you hit their car, having a clear chance of avoiding hitting the car, you would not be able to sue them for the damages to your car. Exceptions to the burden of proof being on the victim. Normally, the burden of proof to show negligence and fault, or duty, a breach of duty, actual damages and proximate cause, is on the victim. They must show all of these things in order to make a claim against the defendant. But there are some exceptions. The first is res ipsa loquitur. Res ipsa loquitur is Latin for the thing speaks for itself. This is commonly called into court when something is so obvious that it doesn't need to be proven. This is common in medical malpractice cases, such as a sponge was left in a person's body during a surgery, or the wrong limb was taken off during the surgery. In these cases, there is no need for the victim to show negligence. Next, negligence per se. Negligence per se means that a law has been broken. These are the cases where a criminal law actually has been broken, and therefore there's no need to show that the defendant was negligent. So if it's already been established that a person was drinking and driving, a victim of a car accident caused by that driver doesn't have to prove that they were negligent. Last, a special case of tort, which is absolute or strict liability. With absolute or strict liability, it doesn't matter whether or not you were negligent. Negligence is irrelevant or not a factor. The situation itself makes one party liable to another. Examples are products and inherently dangerous activities are considered strict liability. So, for example, exploding or imploding a building is considered inherently dangerous, and if someone is injured during that activity, negligence is not a factor. The person responsible for the activity is liable for any damages. And the same is true with products liability, where the manufacturer is liable if someone is injured, although manufacturers do have certain defenses against legal liability. And next, work-related injuries, which are considered absolute liability. If an employee is injured on the job, the employer is liable. There is no need to show that the employer was negligent. And that's the end of our discussion of the liability risk.